Hello everyone, I am Advocate Florence Subrin from Tri-beauros Legal Services. Check bounce is one of the most common financial offences in India. Let's see what are the legal remedies available and the process to file a case and some tips to avoid check bounce. The check bounce is when a check is received from the drawer and is presented in the bank for the payment and gets dishonored by the bank for various reasons. Check bounce is an offence under Section 138 of Negotiable Instruments Act. The amount mentioned on the check has to be a legally enforceable debt. For example, people issue blank checks with just a sign on it. But sometimes the receiver of the check fills an excess amount and files a case. In that case, the issuer has to prove to the court what exactly is his liability. In Star Key Laboratories India Private Limited versus Sanjay Gujral, the Delhi High Court acquitted the accused since the check amount was more than the liability. Sometimes the issuer of the check submits to the court that they've lost the check and they don't even know how the check landed up in complainant's hands. Please note that the burden of proof lies on the issuer of the check. In Ravi versus Kumareshan, Madras High Court held that the accused has to explain the court as to how his signed check is in the hands of the complainant. He cannot escape his liability by just giving some random answers. When there's a check bounce, the private complaint has to be filed in Judicial First Class Magistrate Court near the receiver's bank branch where the check is presented. Once the entire trial is over and if the accused is found guilty, then he can be punished with a fine which can be double of the check amount or with an imprisonment which may extend to 2 years or both. What are the reasons for the check bounce? It could be drawer's account closed, stop payment, insufficient funds, wrong date, mismatch of signature, damaged check, validity of check gets expired, mismatch of figures and words of the payment. Now, let's see the steps to file a case. First of all, the payee has to present the check within 3 months of the date of its issue. But if the check is dishonored, then the bank issues check return memo with the reasons. And as a second chance, the check can be resubmitted within 3 months from the date on the check. After this, the receiver should send a demand notice within 30 days of the receipt of information from the bank. In that notice, the payee has to mention all the important facts such as the nature of transaction, amount, date of depositing the check, and when was it dishonored by the bank, etc. And if the issuer fails to pay the amount within 15 days of the receipt of the notice, then the aggrieved person can file a case within 30 days. Summons and notices. The court summons and notices can be sent via India Post, email, fax, and instant messaging applications like WhatsApp. The 2 blue ticks in WhatsApp would convey that the receiver has seen the notice. Serving the notices and summons. It is deemed that the notice is served even if the drawer accepts or declines the notice. Sometimes the issuer or the drawer is unavailable to serve the notice. In that case, the court allows for the substituted service. That is, the summons are affixed in the courthouse, drawer's house, workplace, or can be published in 1 or more newspapers. Let's see what are the documents required to file a case. While filing a complaint, the complainant must submit all the important evidence such as original check, bank memo which has the reasons of check bounce, and demand notice which is sent to the issuer, the postal acknowledgement card, and also if there are any supporting documents like promissory notes or any agreement would be really helpful in winning the case. Once the case is registered, the court issues summons to the accused to appear before the court on a specified date. Just in case the accused fails to appear before the court on that date, the court has complete authority to issue a bailable warrant. If that repeats, the court will issue a non-bailable warrant of arrest against him. Section 138 of NI Act is a compoundable offence. That is, both the parties can compromise and resolve their disputes instead of going through a lengthy trial. If the accused makes an application for compounding at the first or second hearing, then there would not be any cost imposed on him. But in the subsequent stages, that is from the third hearing, 10% of the cost would be imposed on the check amount. 15% if it's in the session court or the high court. It's even more higher, that is 20% if it's applied in the Supreme Court. Deposit fee. As per the amendment on September 1st, 2018, the Supreme Court held that the accused has to deposit 20% of the check amount in the court, and that too within 60 days. That amount is given as an interim relief to the complainant. And when it's an appeal, the accused has to pay 20% of the fine awarded by the trial court. In case the issuer of the check is acquitted in the case, the complainant has to repay the deposit amount with the bank interest as on the date of the release within 60 days from the date of the order. Let's see some exceptions where one cannot claim the check money. For example, if the check is issued as a gift or donation. When the check is issued as a security, in this case, the complainant should prove that the money lent is legally valid, and especially when there is an undated check, the complainant should prove that as on the date mentioned on the check, there is a legally enforceable debt. If the complainant successfully proves this to the court, then it's up to the accused to prove that he has discharged his debt or paid the debt and the check was issued only as a security. Only then he can be out of the case. For this, one has to maintain all the proper documentation to avoid complications. And the next point is check expiry. If the receiver presents the check in the bank after 3 months from the date on it, it is invalid. In such cases, one can file a civil suit, whereas the limitation is 3 years. The next point where one cannot claim the check money is if the obligation is not legally enforceable. For example, money lender lends money without any license, or if a person lends the amount which is not disclosed in his tax. In such cases, it is not legally recoverable. Forensic lab. If the issuer believes that his check is forged, be it in the signature or the extra amount mentioned in the check, etc., he has to file a petition before the court seeking to send the check to the forensic lab where the handwriting expert determines the genuineness of the document. What happens if there is a repeated check bounce? The check bounce can be extremely damaging towards the CIBIL score of the accused, due to which he may not be allowed the loan from a financial institution. Also, the check bounce can result in the civil and criminal lawsuits against the drawer. And the banks impose penalty on the check irregularities on the drawer and the aggrieved party. And the other negative impact is where the banks have an authority to stop issuing the checkbook facilities to the drawer if the check bounce repeats 4 times on the checks valued over 1 crore. And when it comes to the check bounce in EMIs, the banks have absolute authority to withdraw the amount from the defaulter's active accounts. Well, here is the last segment of a presentation: safety measures to avoid misuse of check. The first point is it's always advisable to issue crossed account payee only checks in order to avoid its misuse. And in a case Jayalakshmi Natraj versus Gina and Co., Supreme Court advised that women not to sign on the checks in the partnership business when they are not fully involved. And the third point is avoid cash transactions. Instead, go digital, especially when a person takes a loan and pays partial amount in cash. It becomes difficult to prove in the court. In such cases, always keep the payments in writing along with the witness signatures to avoid the complications. In the agreement or the promissory notes, please do mention the reasons of the transaction. And very importantly, once the loan amount is repaid, check has to be taken back. But if the other party says the check is misplaced, then do take that in a writing, or else the unforeseen check bounce case can hit back. The validity of the check is 3 months, and for example, if the drawer can't pay the amount in 3 months, then date should be avoided, but the rest of the details must be filled. Cross-check amounts in the digits and the words. The next point is when a check is given as a security, one has to make sure that the promissory note has to be written. It typically contains all the terms pertaining to the principal amount, interest rate, maturity date, date and place of the issuance, and issuer signatures and witnesses. And the last but not the least point, if the check or the checkbook is lost, file a complaint in the police station and submit the complaint copy in the bank. So the bank instructs the stop payment on those checks. And that's it for today. And for any queries or legal assistance, please do contact us with the details mentioned on the screen. And if you would like to know any particular topic on law, please do leave us a comment. Stay safe and stay healthy. Thank you.